I just wanted to welcome everyone here this evening to this debate. I'm Katie Wheatley, I'm head of the crime team at Bindmans, and I've got the pleasure of welcoming all of you here on behalf of UCL and Bindmans to our annual debate, which is now in its 13th year. Thank you for attending what is going to be, I'm sure, a fascinating debate. I also wanted to let you know there will be refreshments afterwards outside, and we would be delighted if you would join us then as well. And that will also be an opportunity for some more informal discussions about the issues that are going to be raised. I wanted also to thank our speakers. Joshua Rosenberg, who is our chair, will be introducing them. But thank you to Alex Bailin, Rohit Kachroo, Lord Anderson of Ipswich, and Jodie Ginsberg, as well as to Joshua Rosenberg for his input, and also to UCL for partnering with Bindmans for so many years and providing this fantastic venue. As you all have read, our topic this year is state security and press freedom. We expect the state to protect our democracy and to keep us safe. Press freedom is, of course, an integral part of a properly functioning democracy. We would like the two of those aspects, protection and press freedom, to work in harmony. However, frequently in recent years, concerns have been voiced about the impact of new legislation and other developments on press freedom. At the time we and UCL decided on this topic, we were looking at legislation that came into force in the UK this year, including Overseas Production Orders and the Counter-Terrorism and Border Security Act 2019. But little did we know that just around the corner there would be some further events unfolding, some of which will be touched upon this evening. But the ones that occurred to me were, first of all, the most tragic murder of Lyra McKee in Northern Ireland, and then the Belfast High Court ruling in relation to the journalists' material Barry McCaffrey and Trevor Burney, and then, of course, last week, the raiding of ABC's offices in Australia. All of these events are illustrations of the tensions that this debate, we hope, will address. There will be plenty of time for questions. I also need to let you know that the debate is being recorded and will be made available on our website after the event, but the Q&A session won't be recorded. So now I'm going to hand you over to Joshua.
Thank you very much. Thank you very much, Katie, for asking me to chair the UCL Bindmans debate on state security and freedom of the press. It's not a formal debate as such, despite the title, not least because I suspect that most of the speakers are going to agree with one another and perhaps even agree with all of you. But I shall try to inject a note of disagreement into the discussion. Each speaker will have 10 minutes to outline what they want to talk about, and then we'll have a discussion among the speakers, and then we'll bring in the audience. And the aim is to finish at 7:45, and after that there are drinks immediately outside till about 8:30. As Katie said, we're here to talk about the balance between press freedom and state security, and it is indeed an extremely topical subject. In today's papers, we read that MI5 has been accused of extraordinary and persistent illegality in a challenge brought by Liberty, the human rights organization. One of our speakers yesterday, a report he wrote was published by the government. It mentioned the dystopian film Minority Report and an awful lot of initials and acronyms and abbreviations which are take a certain amount of working out, but it did, as the Guardian report today says, it suggested that the security services might soon be able to scan sensitive data from a significant proportion of the British population for signs of terrorism. And then, as Katie said, last week the police service of Northern Ireland dropped their investigation of two journalists, Trevor Burney and Barry McCaffrey. They'd been arrested after the broadcast of a documentary they helped to make about the police handling of the Loughin Island killings when 6 Catholics were murdered by loyalist paramilitaries in 1994. I'll be interested in the views of the panel as to whether this reflects badly on press freedom in the sense that they were arrested and they had their property seized, or perhaps is a more encouraging sign in the sense that the courts intervened and the charges against them were dropped. But I hope that our discussion will range much more widely about the risks that journalists face, both here in the United Kingdom and in the wider world. Katie mentioned the raid by the Australian Federal Police on the headquarters of the Australian Broadcasting Corporation in Sydney. The police were investigating a leak of classified information alleging that Australian special forces were involved in killing unarmed men and children while serving in Afghanistan. So, plenty to talk about. Let me introduce our panel in the order in which they'll speak. And I think you can probably all remain sitting down if you're comfortable doing that. It's entirely up to you. First, Lord Anderson of Ipswich, Bailin QC, better known to most of us as David Anderson, the independent review of terrorism legislation from 2011 to 2017. He used to be a specialist in EU law, perhaps a dying art these days, but when he was working in that area, he used to monitor freedom of the media for the Council of Europe in Eastern Europe. He's now back in practice at Brick Court Chambers, but still seems to be called in every year or so by the government to resolve some problem or do some inquiry. Jodie Ginsberg, Chief Executive of Index on Censorship, which campaigns for and defends free expression worldwide, publishes work by censored writers and artists, promotes debate, monitors threats to free speech. Before joining Index on Censorship, Jodie was a foreign correspondent, business journalist, and was UK Bureau Chief for the Reuters news agency. Next to her is Alex Bailin QC, a silk at Matrix Chambers, who specialises in financial crime and fraud, general crime, extradition, human rights and public law, and he also knows a thing or two about media law, privacy and public international law. He read mathematics at Cambridge and started life as a derivatives trader in the city. And next to him is Rohit Kachroo, who is security editor for ITV News, concentrating on counter-terrorism and national security, both in the UK and abroad. He was previously UK editor and Africa correspondent. He started his career in regional television news before becoming ITV's crime correspondent in 2010. Ladies and gentlemen, please welcome your panel. David Anderson, over to you.
Thank you. There absolutely should, and I hope always will, be battles between journalists and securocrats. If there weren't, then one or other of them wouldn't be doing their job. We shouldn't, as it seems to me, trust either side correctly to balance the interests concerned, the competing public interests. That has to be ultimately the function of Parliament and the courts. So how are they doing? I'm going to start with an anecdotal reflection from Parliament in which I have not been present for very long. But one of the first bills that came along after I joined last summer was the Counter-Terrorism and Border Security Bill, which became an act earlier this year. And as the bill had almost completed its passage in the House of Commons, the government chucked in a new criminal offence, the so-called designated area offence, which criminalises United Kingdom citizens or residents who travel to or remain in a place that has been designated by the Secretary of State. And the other countries with similar laws, Australia and Denmark, have designated places like Raqqa and Mosul. This, as I say, was chucked in as an afterthought. It had a reasonable excuse defence, but it had no proper defences. And the first thing I did was put down a series of amendments aimed at securing some defences, or some at least even more than that, some activities to which the offence simply didn't apply, to which the Act wouldn't apply. And I just thought the reaction of the Minister was quite interesting, because when you do that, you go and see the Minister and you argue your case. I said carrying out work as a journalist should be a defence, or should be a reason for the non-application of the Act, and that was agreed very easily. And why politicians should be so keen to propitiate journalists, I don't know. We had no trouble with that one at all. Much more difficult were providing aid of a humanitarian nature. We had a lot of trouble with that. And we had attending the funeral of a relative and a couple of others. The one that proved completely impossible was conducting peace-building work, which sadden me because I'm the chair of a charity that conducts peace-building work in areas where there are terrorists, and I'm sure the employees would very much like to know that the Act doesn't apply to them when they're doing their job. So does that mean that Parliament is actually quite soft on journalists and quite amenable to their legitimate concerns? I thought it might be worth just mentioning a couple of other acts to see whether that's the case. And one is the Investigatory Powers Act 2016, which again I had quite a lot to do with, though not particularly when it was going through Parliament. Again, it seems to me journalistic concerns received quite a favourable hearing as that bill went through, and a number of quite significant amendments were made. So, in particular, any application for authorisation to identify or confirm journalistic sources can only be granted if a judicial commissioner, who in practice is a High Court judge or above, is satisfied that there is an overriding public interest. Though, rather sadly, in my view, there is no right of the journalist to be represented at such hearings, or even any provision for such hearings to take place. But does that go far enough, that scheme of protection in the Act? I've got to be a little careful because it's currently subject to litigation brought by Liberty. But we do know from the Big Brother Watch case in Strasbourg last summer that the predecessor Act, RIPA, was defective in two respects where journalism was concerned. First, there was insufficient control of search criteria when interrogating the product of bulk surveillance. So if they put a tap on a cable, they need a warrant to do that. But they don't need any specific warrant or any specific oversight in relation to the choice of selectors. So there'd be nothing to stop them choosing a journalist's email address, for example, as a basis for search. I was quite pleased to see the court say that, because I said something similar in my own report. And then secondly, they thought there were insufficient controls for when you were seeking an authorisation, not with the purpose of obtaining a journalist's sources, but an authorisation that was perhaps liable to disclose a journalist's source by a side wind. Now, I don't know whether both of those defects has been remedied in the new Act. I think there's an argument that at least one of them has been, but that no doubt will be determined by the courts. The other Act I wanted to mention goes back a bit. In fact, it really goes back to the Middle Ages and the old offence of misprision of treason. But it now takes the form of Section 38B of the Terrorism Act 2000. And that's the provision. It doesn't just apply to journalists. It applies to any person who has information which he knows or believes might be of material assistance in preventing the commission of an act of terrorism or prosecuting or convicting a person in the UK for a terrorist offence. Any person who has that information must show it to the police. Journalists, of course, have a duty to protect their sources, but Section 38B may require them in some circumstances to shop those sources to the police. Is that an excessive impediment to investigative journalism, for example, into Syrian fighters, or indeed to journalism of other kinds? I looked at this quite a bit when I was independent reviewer of terrorism legislation. I discussed it with undercover journalists. I discussed it with other journalists. Some people didn't like it. Others thought it was justified. The results were inconclusive, as I recorded in my reports. Maybe the current independent reviewer, who I think is lurking near the back, Jonathan Hall QC, will revisit the issue. I wasn't sure why people weren't more hostile to 38B. There is, of course, a reasonable excuse defence. Perhaps people took comfort from that. There's also the CPS guidance for prosecutors in cases involving the media. That guidance relates to the public interest limb of the standard prosecutorial test, and in effect it requires an assessment to be made as to whether the public interest served by the conduct in question outweighs the overall criminality, and it counsels taking particular care in cases which involve the disclosure of journalistic sources. And then there may be the fact that no journalist has ever been prosecuted for 38B. It's used quite a lot for family members of bombers and so on. The one who came closest back in 1978 was young Jeremy Paxman, because he had information about or was said to have information about an IRA roadblock, which he had not communicated to the RUC. And he got a very stiff letter from the Attorney General saying he better watch his step. And that's in his autobiography. But as far as I know, there's been nothing since then. Richard Danbury, the former BBC Newsnight producer, wrote an interesting article on Section 38B earlier this year, based on a lot of interviews with journalists, in which he concluded that the case for repeal had not been made out. He said this: surely a serious journalist, or indeed any responsible citizen, should have no objection to helping the police prevent terrorism. Well, I'm sure that's right in the classic ticking time bomb scenario. On the other hand, I think one has to factor in the fact that a lot of the terrorist offences these days are extremely peripheral. A good example is a designated area offence. So, as a journalist, you could go to Raqqa or Idlib or wherever it is, confident in the knowledge that the law doesn't apply to you because you're a journalist. But as soon as you talk to a British person who is there, you are talking to someone who is committing a terrorist offence because they are in a designated area unlawfully, and therefore it seems quite difficult perhaps to do your job. So I think that's unfinished business. Well, so much for Parliament. I've got a couple of minutes left, so let me just say a word about the courts. And let me use the example of a Bindmans case, the case of Miranda, which will be familiar, I expect, to many of you. David Miranda was the spouse of the Guardian journalist Glenn Greenwald, and Miranda was stopped going through Heathrow Airport under Schedule 7 to the Terrorism Act 2000 back in 2013. He was carrying encrypted material derived from data obtained by Edward Snowden, including top-secret material from GCHQ. So quite strong facts, if ever there were strong facts in a case of this nature. The Court of Appeal, reversing Law Justice laws at first instance, found that there were insufficient safeguards against the unlawful exercise of the Schedule 7 powers in cases involving journalistic freedom, and that what was required was some element of independent oversight before journalistic material seized at the port was examined by the police, or at least in urgent cases, independent oversight immediately afterwards. That's now provided for in the relevant law and codes, both under Schedule 7, which you can use to determine whether people are terrorists, and under the new Schedule 3 to the 2019 Act, which the police can use to determine whether people are engaged in hostile state activity. So, to conclude, the interests of the press and of the security and intelligence agencies, in particular, it seems to me, are bound to conflict. But excessive secrecy serves the interests of neither. And the security and intelligence agencies themselves learned that lesson after Snowden, when the journalism really seemed to serve one of two narratives. One was of a security establishment out of control, pursuing its own sinister agenda, a narrative epitomised by the rather juvenile but very catchy slogan, Snooper's Charter. The alternative narrative, which I'm afraid was adopted by some otherwise very reputable journalists who were given privileged access to places like GCHQ, was a narrative of our brave boys and girls straining every sinew day and night to keep us safe. And I don't think either of those narratives is particularly illuminating, but I don't really blame the journalists for that. I think the problem was a lack of basic information, a lack of transparency, or at least translucency, about what the agencies are doing. Since 2015, I would argue we have seen a vast increase in transparency. I think Snowden was at the root of some of that, and he has sort of prompted an avalanche, certainly in this country and I think in many others. I hope on the back of that, we're also beginning to see a more informed and a more nuanced journalistic interpretation of the covert world.
David, thank you very much indeed. A very interesting point, which we won't discuss now, but which may come up in conversation, which is the absolutely basic point of what is a journalist and how is one to be defined. Okay, we'll go on to Jodie, and we'll see where we get to with that. Jodie.
Thank you, Joshua. And thank you to Bindmans and UCL for this invitation. It's timely not just because of the cases that we've heard about this evening already, but also because you may not be aware, but the Foreign and Commonwealth Office has designated this year media freedom as its flagship campaign. Next month, the UK will be hosting foreign ministers and others to examine how states can do better in protecting media freedom, and this seems extremely timely. Whether or not the UK is able to ensure that it is protecting its journalists at home is another matter, and that's something that I will talk about and cover now. But what I want to do is look broadly at the situation facing journalists as they look at the ever-growing raft of national security laws. And I want to start by giving you an anecdote about Index on Censorship. So Index on Censorship, the organisation I run, has been going since 1972. In 1989, one of our sponsors, after the fall of the Berlin Wall, turned to us in all seriousness and said, "That's wonderful, you can shut up shop now. Job done, you can go home, censorship is over." Excellent. And fortunately, those individuals who ran Index on Censorship at the time had the wisdom to know that that wasn't necessarily the case and carried on going. And certainly in the 5 years that I've been at Index on Censorship, we have seen the space for civic discourse, democratic space shrinking. And in part, that's happening because we're seeing a move back towards a sense that safety and security are paramount, and in fact more important than some of the fundamental freedoms that were celebrated at the time of the fall of the Berlin Wall. And I often think of the Benjamin Franklin quote, "Those who would give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety." That's something that I hold in my head frequently when I think about the ways in which governments all over the world, and not just the autocratic ones we associate with censorship and threats to media freedom, are expanding their national security laws in ways that threaten freedom of expression and freedom of the press. There is a very mixed audience here, I suspect. Some of you will be absolutely au fait with every single letter of the legislation as it relates to media freedom and security and terrorism legislation in the UK, and others perhaps not so. So forgive me if I quickly rehearse some of the protections that exist already for freedom of the media in the UK and internationally. And essentially in the UK, that hinges around something called Article 10 under the European Convention of Human Rights, which protects freedom of expression, which gives everyone the right to freedom of expression. But what's important about Article 10, when we start to think about the ways in which national security laws are being used and abused, are the caveats included in Article 10. And I just thought it would be useful to go over those as we start to think about whether national security laws have got the balance right, as David referred to. So the second part of Article 10 reads as follows: "The exercise of these freedoms, since it carries with it duties and responsibilities, may be subject to such formalities, conditions, restrictions or penalties as are prescribed by law and are necessary in a democratic society." And this is the key part: "In the interests of national security, territorial integrity or public safety, for the prevention of disorder or crime, for the protection of health or morals, for the protection of the reputation or rights of others, etc., etc." And because of that carve-out, if you like, that's the justification that many states have used to justify the expansion and the continued expansion of national security laws. I don't think it's any coincidence that the expansion we're seeing in national security laws, anti-terrorism laws, counter-extremism laws that we've seen in the UK and elsewhere has come at a time also when we're seeing threats to journalists increase. We at Index on Censorship for the past 4 and a bit years ran something called a Mapping Media Freedom Project, where we recorded threats to journalists in the European Union and neighbouring countries. And there were 269 reports of cases in which national laws were used in a way that threatened media freedom. Now, one of those we've already heard about today is terrorism legislation. It's been used in the UK. We talked about RIPA earlier. But in many other countries, you may be familiar with the way in which terrorism laws are being used in Turkey to essentially jail any journalist who disagrees or criticises the government, but they're also being used in countries like France. So last month, a senior correspondent for Le Monde was summoned for questioning for her writing about a corruption scandal that involves the president. We've seen it happen in many other places. We heard, and I hope we'll talk about last week, the raid, the huge raid on the public broadcaster in Australia, which had a warrant so wide that the mind boggles. Essentially, the warrant that was given to police who raided the public broadcaster, so ABC, the equivalent of BBC, gave police the powers not just to seize material, but also to edit or delete material. And I think it's worth thinking about that for just a second. That, to me, sounds like an invitation to plant evidence by the police, if you want anything else. But that came again on the basis of national security laws, and these things are happening in countries that aren't simply places like Turkey and Russia, where countries like the UK like to point the finger. And it's not just in cases that relate to corruption, or even are tangentially related to terrorism. We've seen in places like Spain and France, even jokes are landing journalists in trouble. So in Spain, a comedian was taken to court in 2015 for a satirical sketch, and he faced charges under the glorification of terrorism legislation, which, as a reminder, we also have here in the UK. So the idea that these things simply happen elsewhere is false, and they are being used to prosecute and persecute journalists in places, including the UK, but in places like Spain and France. Terrorism laws are also used to increasingly protect the image of the state. We've seen restrictions on the press growing in places like Hungary and Poland, for example. And in Poland in particular, the protection of the image of the state as being integral to national security is becoming increasingly important. So we've seen cameraman there, for example, was investigated by police for videoing a neo-Nazi group because that was considered to be, if you like, damning. Coverage of neo-Nazis was equivalent to engaging in that activity. The idea, I think, that I want to stress is, and I will come back to repeatedly, is it's very easy, I think, for governments, and I am particularly concerned about this when it relates to the Foreign and Commonwealth Office and its focus on media freedom, to point the finger elsewhere. We like to say that Russia are the bad boys, or look at places like Turkey. But as we've heard from David, those pieces of legislation are also used here. And the most recent example, I think, should give us pause. And it's not simply the width of the legislation, it's also the way in which it's interpreted. So last month, 2 journalists had warrants that were issued against them quashed. 2 journalists in Northern Ireland, we heard briefly about them. The case hasn't been much covered, but it's worth knowing that those 2 journalists who had produced a documentary that essentially investigated police collusion in a massacre were the only arrests that have been made in relation to that case, were the journalists who investigated that. They both had their homes raided in the early hours of the morning by armed police. More than 100 armed police were involved in that raid. The police then went to the offices of the production company and tried to seize the server of the journalists. Now, the journalists were not just engaged in this report, they cover all sorts of investigative journalism across the world. So that server contained information about investigations they were carrying out in Honduras, which is one of the most deadly countries in the world for journalists. Source protection, quite important. They weren't, the office staff prevented them from taking away the server, so they copied the entire thing and held on to the records for the past 12 months. It was only after the court quashed those warrants that the police dropped the case. And this is where I want to leave you with. The most worrying thing to me about that case, apart from the issuing of the warrants in the first place, was the apparent lack of understanding by the police who went after the journalists in the first place. So in order to protect themselves, the PSNI invited, so the Police Service of Northern Ireland invited Durham Police to come in and run the investigation, essentially. And the Chief Constable of Durham Police, after the decision by the Northern Irish High Court last month, said, "I thought the law was in a different place." Essentially, the Chief Constable of Northern Ireland, who sanctioned effectively this unprecedented raid, I would say, on 2 journalists investigating police collusion and corruption, did not understand the law sufficiently. And I think one of the major pleas that I would have, essentially, as we think about how we can do better to protect journalists and media freedom going forward, is to ensure that both lawmakers, and we are hugely reliant on the Lords to actually come in and make sure legislation doesn't end up in a terrible place, and I'm very grateful to David Anderson for doing that, but both lawmakers and the police service have a much better understanding of the protections that exist for journalists. Thank you.
Excellent. Jodie, thank you very much indeed. And that's a perfect cue to Alex, who's going to tell us a little bit about the law.
So, David says we need a healthy battle between journalists and organs of the state. So I'm going to attempt in 10 minutes to do a magical history tour and let you decide, have we got the balance right? I'll keep myself, for timing reasons, to the United States and the United Kingdom, the two most liberal democracies in the world. 1971, Daniel Ellsberg, US military analyst, leaked the Pentagon Papers, which revealed the true loss of life in Vietnam. That changed the course of the Vietnam War and ended it sooner than otherwise. The authorities wanted to prosecute him under the Espionage Act 1917. That prosecution fell apart only because they bugged his psychiatrist's office. The New York Times wanted to publish the Pentagon Papers, which Daniel Ellsberg had leaked. The Nixon administration tried to injunct the New York Times, goes all the way to the US Supreme Court in a great victory for the First Amendment, freedom of speech. But of course, that's an old case. That's just the dark, paranoiac days of Richard Nixon, isn't it? So let's fast forward to 2013. Chelsea Manning, US Army intelligence analyst, sentenced to 35 years imprisonment for offences under the Espionage Act 1917. Admittedly reduced by Obama, put up again when Manning refused to testify against Assange in the grand jury, for offences of stealing the material which Julian Assange is alleged to have passed to international news outlets for publication via WikiLeaks. That material revealed, for example, what was happening in Guantanamo, revealed that the United States routinely bugged the United Nations, revealed, for example, that the United Kingdom lied about the Chagos Islands, included footage of the United States Apache helicopters shooting at Reuters cameramen in Baghdad. Assange himself now faces, although the full details will be unveiled on Friday in his next court appearance, he now faces a superseding indictment under the Espionage Act 1917 for publishing the material that Manning is alleged to have provided to him. Now, is Assange a journalist? Should he be entitled to First Amendment protections as a non-US citizen? Is he simply a hacker's assistant? What about Edward Snowden? David referred to the wave of transparency that's followed the Snowden disclosures. He's right, but let's not forget that Edward Snowden was charged under the Espionage Act 1917. He will hold himself up in Russia rather than a small South American embassy. The material which he obtained revealed the existence of the PRISM and Tempura bulk spying data collection programs, which governments on both sides of the Atlantic had gone to extreme lengths to keep secret. He's referred to the case of David Miranda, which the Court of Appeal held that use of anti-terrorist powers, let's not forget that David Miranda was the partner of a journalist holding the material that Snowden had about PRISM and Tempura, stopped under anti-terrorist powers which the new independent reviewer has described as breathtakingly broad. The courts obviously had serious issues with those powers. And yet, in the same vein, we have new enhanced legislation. The Counter-Terrorism and Border Security Act 2019 rebrands those anti-terrorist powers. It introduces new David Miranda border-type powers to stop and detain journalists without reasonable suspicion who have confidential journalistic material relating this time to hostile activity. That's broader than merely material which is related to terrorism. Hostile activity material includes, for example, unwittingly carrying espionage-related material. It's a criminal offence not to answer questions about that material. There is no public interest defence. There are safeguards for journalists, which are welcome, but nothing like the strong safeguards which exist if a journalist is raided under the Police and Criminal Evidence Act. There are also new offences of viewing terrorist material online without any terrorist intent. Now, after much intense lobbying, there is a defence for journalists and others who are doing academic research, which is welcome. But there are new offences also in the 2019 Act of expressing an opinion or belief that is supportive of terrorism, being reckless as to whether the audience may thereby be encouraged. Now, to me, that does feel like thought crime. That is another minority report, and indeed it reverses a Court of Appeal ruling to that effect. David mentioned the Section 38B offence, which has not been used against a journalist, but I can't help name-dropping a former client of mine, Shiv Malik, represented by the illustrious firm of Bindmans, who was an ex-Guardian journalist who interviewed a reformed Al-Qaeda terrorist and was writing a book about that, which comes out this week, I think, or next week, called The Messenger. He interviewed this reformed Al-Qaeda terrorist with a view to understanding radicalisation, and he was promptly slapped with production orders. We had a very hard-fought battle not to reveal his source material, and during that hearing the prosecution explicitly refused to exclude the possibility that he would be prosecuted under Section 38B of the material if he were forced to hand it over. The Home Secretary also announced that the ink was barely dry on the 2019 Act, but he'd like to expand the ancient definition of treason to extend hostile activity to include hostile activity against the UK by spies, assassins or hackers directed by a foreign government. Obviously that would have grave implications for journalists were they to have any relationship with people holding that sort of material. I'll just pop back to the 1980s. Clive Ponting. Do you remember Clive Ponting? Mild-mannered civil servant who pointed out, matter of fact, that the General Belgrano Argentinian warship was actually sailing out of the exclusion zone when it was bombed by British forces, not into the exclusion zone, as was claimed in Parliament. Catherine Gunn, one of my favourite ever clients, I'm bound to say, mild-mannered GCHQ Mandarin translator, who revealed the fact that the United States had contacted Britain and asked us to help bug the UN and obtain a second resolution by fraud in the run-up to the Iraq War. Each of them were prosecuted under offences of almost strict liability in court number 1 of the Bailey. Now, neither was convicted, but the jury had to ignore the evidence and the judge's summing up in Ponting's case. And in Catherine Gunn's case, we had to, and I have to always write this down, we had to rely on the defence of necessity in preventing an unlawful war in international law in order to get the tanks off her lawn. We still have no public interest defence to those Official Secrets Act offences. Those are the British equivalent of the Espionage Act 1917. We have no public interest defence for journalists, whether they're charged with Official Secrets Act offences or anti-terrorist disclosure offences. And the Home Secretary recently announced we're to have a new Espionage Act, which I hope at last will get a public interest offence. My throat's very sore on that front. So I leave you to decide, have we got the balance right?
Alex, thank you very much indeed. In a moment, we shall also talk about the extent to which we can rely on the courts in this country, and if not the judges, then the juries. But before that, we have Rohit, who at one point, I can reveal to you as a television journalist, is actually going to show us some moving pictures. But start speaking first, and I'll play the pictures when you're ready.
Thanks very much. And I wanted to add to some of these points with a bit of a sort of reporter's perspective, a bit of a personal perspective, at what is clearly, even though it might not always look like it from the outside, a very difficult time for journalism. And the new legislation, as Alex has just highlighted, really adds to some of the existing concerns that journalists and some news organisations already have. Many journalists want greater clarity on several of the important aspects, those relating to travel to designated areas, the viewing of terrorist material online, and certainly to border stops as well. What guarantees there are around sensitive material that journalists might be carrying, and for sources that we obviously need to protect. And when there are potential defences, what will we have to disclose in order to mount a case? Who can and cannot claim to be a journalist in this era in which so many campaigners or extremists claim to be reporters? And what about freelance journalists who don't always have the same protection that we might with access to a newsroom lawyer? So tonight I want to highlight some of the growing challenges faced by those of us trying to report, particularly on counter-terrorism. The threats those challenges pose to our independence and impartiality, and the realities of frontline reporting as well, that some legislators here and abroad do often seem too tempted to ignore. And I'll talk a little about the reality of how the legislation, in tandem with other challenges to journalism, which we can't ignore here, might threaten the ability of a free press to operate. Let's start in Australia, once again, where those raids last week on the public broadcaster, which had dared to expose the clandestine operations of special forces in Afghanistan, was chilling. 9,000 items downloaded from newsroom computers, email accounts accessed and searched. This was, for many reporters, infuriating, disturbing, but it was perhaps not surprising to some reporters on this beat, because it seemed to be very much in the same direction of the global direction of travel on this issue. A growing willingness by states to challenge, even to trample over the independence of the free press. And we cannot consider the impact of the new legislation here in the UK in complete isolation from, sieved away from the increasing challenges being faced by reporters covering terrorism in all liberal democracies. Firstly, the challenges posed by the growing risks to our safety. Let's not forget, Islamic State assassinated reporters. The TV tape on a vehicle in a war zone, once as close as you could get to a surefire ability to protect yourself, well, that, if anything, perhaps makes you now even more of a target. Last year, 34 journalists were murdered in direct retaliation for stories that they wrote. 53 more journalists died while doing dangerous work, according to the Committee to Protect Journalists. That's a significant rise on previous years. But this isn't just about war zones. Even here in London, during the last few months, reporters have received abuse in courtrooms by extremists of various kinds, while covering trials or court hearings. And of course, the case of Jamal Khashoggi showed that the most serious threat to journalists can come from nation states too. So perhaps some consideration needs to be given to special legal protections for journalists operating in these difficult circumstances, or those who are targeted because of the stories that they cover. Secondly, we're being challenged, of course, by these anti-media conspiracy theories stirred up by politicians, not just the one in the White House, but leading figures even here in the UK, some who should know better, some who use terms like mainstream media as a sort of demeaning phrase to dismiss the validity and the impartiality of what it is that we do. And so extremists and politicians have unwittingly teamed up to create this growing environment in which it's far easier to question the legitimacy of journalism. And so at a time when getting to the truth is harder and anyone can choose their own alternative facts, legislators attempting to protect national security must also make an effort to stop legitimate journalistic objectives from becoming harder to reach. And this is the essential context within which I think all journalists will be assessing this new legislation. So my job is to report on counter-terrorism and extremism. Attacks here in the UK and abroad, it's to expose extremist groups, it's to explain IS and other networks in Syria and abroad, it's to investigate those who commit acts of terror, to hold to account those in authority who are meant to stop them. It means talking to sources in government, to officials, to agencies. It means also talking to people on the fringes of society. Yes, it sometimes means talking to and listening to extremists and their associates. It means travelling to dangerous places. That requires time, contact building, enterprise, knowledge, and personal risks, be that here at home in the UK or when entering conflict zones abroad. And for the good of our viewers, it requires me and my colleagues to view extremist content in the very darkest corners of the internet. That work needs to be protected, in my view, and from a journalistic perspective, the most important consideration for the legislation is whether it affords the space to do this important work while maintaining independence and impartiality and not being interfered with. This is really legitimate journalistic activity. So, I want to show you a few examples, just 3 short clips of work that we've done in the last few weeks. And these stories might help you to illustrate some of the issues that we've been talking about tonight.
This is the man known as Jihadi Jack.
Hello, Jack.
Hello.
I'm Rohit from ITV.
Okay.
He's accused of coming to Syria to fight, but now says he just wants to leave.
Miss my mum. That sounds a bit toddlerish, but in 2 years, 5 years I haven't seen my mum. 2 years I haven't spoken to my mum. I miss my mum. Even I can just see my, I'd like just a phone call. I don't know if Britain can do that for me here, but I'd like just a phone call to my mum.
He has no proof that I'm a threat, other than that I was in ISIS.
Tonight, he delivered a response through a letter sent to the family of Shamima Begum by the Home Office and shared exclusively with ITV News. It begins, "Please find enclosed papers that relate to a decision taken by the Home Secretary to deprive your daughter, Shamima Begum, of her British citizenship."
They got this in the post.
Okay.
But I'd come here with a copy of the letter sent to her parents yesterday, stripping her of British citizenship.
Please find enclosed papers that relate to a decision taken by the Home Secretary to deprive your daughter Shamima Begum of her British citizenship. In light of the circumstances of your daughter, the notice of the Home Secretary's decision has been served on file today, 19th February, and the order removing her citizenship has subsequently been made. Okay then.
What do you think?
I don't know what to say. I'm not that shocked, but I'm a bit shocked.
So how does it all work? You know, how do these interviews happen, and how does this apply to some of the issues that we've talked about this evening? Well, they don't happen easily. Don't be fooled by the frequency with which you saw Shamima Begum on the television in February. The process starts with a request for a visa from the Kurdish authorities a few days before we travel. We needed to convince and to lobby officials via our brilliant freelance producers on the ground who've worked on this story for us for 5 years. When access was granted, me and 2 colleagues who were in different countries at the time have to drop everything. We travel with cases of technical equipment to Erbil in Iraq, then a day-long drive to the border with Syria, series of meetings with officials there, another drive to a town close to the camp. And while we were there, we broke the story about Shamima Begum being stripped of her British citizenship, confirmed through sources here in the UK, broadcast from a local producer's suburban front room in Syria. Then we travelled to Al Hol camp where she was to try to find her. We make requests for an interview, firstly with the officials at the camp who'd really grown tired of British journalists from asking for access to her. And then finally, permission from Shamima Begum herself, whose granting of permission on camera was actually the final stage of this long and risky process. Now, during this trip, we were able to see and to show our viewers the impact of coalition airstrikes on the front line, the trauma of Yazidi child slaves who'd just been freed from IS. And this was for a large audience. This is the British mainstream, the millions of people who've just watched an England game or a Martin Clunes drama, far beyond the narrow interest that you might see in a trade journal or viewing a debate such as this one. And all the while, we're having to talk to sources and officials in the UK, Kurdish officials, people in the States, across several European countries, and of course to our managers, our editorial managers, and our lawyers back home in London. and on top of that, obviously, it's a conflict zone. So, we need to think about our safety, the safety of our team, of our drivers, of our local fixers. This is really complicated. This isn't easy stuff, but we have a duty to be there. Islamic State was about to be territorially defeated following a campaign that our viewers had helped to pay for. Dozens of British and former British citizens were in camps as prisoners. So this was a really important story, and these two cases, Shamima Begum and Jack Letts, really highlighted those issues through the prism of these personal tales. Since
about a minute left.
Okay. Since our return, though, from Syria, we've received multiple requests from police forces for unbroadcast material. The pictures and the interviews that we chose not to put on air. Now, ITN's a grown-up and responsible organisation. It's been around for 60 years. We're used to receiving these sorts of requests. But recently, they've become much more common. And I've personally been involved in about half a dozen of these requests over the last few months. The reason for this rise is explainable given the nature of the conflict in Syria. But demanding our material should never be a reflex response, particularly when it relates to individuals who are able and willing to be interviewed by British authorities. Our independence is our greatest asset. We don't disclose material without the requirements of court procedures being completely met. We do not accept fishing expeditions, and we will fight any such attempt to do so. We're not on the side of terrorists because we do not take sides, but that works both ways. We are not working hand in hand with the state, and we cannot be seen to be working hand in hand with the state. It's our impartiality that makes people feel comfortable to talk to us. And if some governments continue to push back against a free press, as many journalists perceive them to be doing, they'll risk the safety of journalists who will no longer be seen as independent.
Okay, thank you very much indeed. Now, I want to start with the definition of a journalist. This may be a trivial point, but it's perhaps one that we ought to get out of the way at the beginning. Rohit, you're clearly a journalist. You work for a recognised news organisation. Jodie, when you were working for Reuters, there's no doubt about that. David and Alex, you are members of a profession. You are barristers. If you misbehave, that title can be taken away from you. I call myself a journalist, but that's me choosing to be a freelance journalist. Nobody awards me the title. Nobody can take it away. And that's possibly an aspect of free speech. Do we actually need a definition of journalism, or is it sufficient for people to say, well, it's clear that I spot a journalist when I see one, she or he works for a recognised organisation or is doing something, or do you think that the boundaries have got so confused with the growth of social media that it's not possible, and perhaps it doesn't matter? Who wants to comment on that to begin with?
Well, I think it's really the latter. I don't think you can compartmentalise a journalist anymore. In the days of Daniel Ellsberg, it was different, you could tell, but now anyone can upload and can report and can publish material to the world at large. And that's why I think when, for example, you're looking at what protections journalists and people akin to journalists need, you should do it in that way. And that's why in the examples I gave, I was chopping and changing between journalists and whistleblowers for precisely that reason.
Yeah, sorry, keep going.
All I was going to say was I think definitions can be both extremely helpful but also extremely problematic. So the more narrow you make the definition, the more you risk people who are engaged in, for example, journalistic activity but wouldn't meet a particular definition that you might choose to come up with, such as the owning of a press pass or working for an accredited organisation, would fall out of that. And in places like, if you think about Syria, for example, there is no formal media anymore because the government destroyed it. So the only people who are engaged in what I think we might agree to be journalistic activity, in other words, recording, for example, atrocities committed by the state or by Islamic State and then broadcasting to that to the world, they're not accredited journalists. They might be, some of them might be activists, but they are engaged in something that we might consider to be journalistic activity. So I think I think it is possible to put in place protections for people who are engaged in journalistic activity. I think defining journalists could end up excluding a vast array of people who might include, for example, whistleblowers.
David?
Yes, there's a sort of catch-22 here, because it obviously makes sense to try and arrive at a definition. But take the Schedule 7 case, take Miranda. Now, it so happened that Miranda's husband at the time was paid by The Guardian. So that was nice and easy for the Court of Appeal, and they could say, well, this was journalistic material because it might end up in The Guardian. But what if that had been someone concerned with WikiLeaks, who self-published and didn't go through the orthodox media? Would that also have been journalistic material? Where do you draw the line? And it's catch-22 because everyone can see that it makes sense to include, in some circumstances, bloggers or people who reach a big audience through their tweets or whatever. But as soon as you do that, you're really applying it to all citizens, and you're diminishing the case for any sort of special protection for journalists at all. So it seems to be pretty unsatisfactory. And I think we were concluding earlier that the question of whether somebody is a journalist or not, if it's going to be relevant in a legal prosecution, and it may well be, is ultimately a mixed question of law and fact, and there may be elements of that the jury have to decide, and that seems very difficult.
Rohit, is there anything?
Yeah, I mean, well, it's such a difficult question. I'm not going to offer an answer, but it's one of the most pertinent questions here. I mean, as you say, the definition of being a journalist has changed so much over even the last 5 years. I mean, we all know of extremists in this country who describe themselves as journalists. But on the other hand, I mean, look at some of the greatest, the most important work that's been coming out of Syria over the last 5 or 6 years. Equally, people who could be defined as being activists. Some of the most powerful and the most memorable and some of the most important pieces of reporting out of Syria have come via activists. And so, I mean, who knows what the answer is? But I mean, this is really going to become far more of an issue because this title, journalist, seems to be something that a greater and greater a band of people are choosing to sort of select for themselves.
Okay, well, let me broaden it to the other question I hinted at, and it's related really, and that's the extent to which we can rely on the courts, at least in this country. I fully accept what Jodie was saying about other countries around the world. But, I mean, is there still, among the judiciary in the United Kingdom, I include Northern Ireland particularly for this purpose, is there still an understanding that the people who a judge or a jury would recognise as journalists are privileged in some way? It's up to them to decide who is a journalist and who is not. We can talk about whether Julian Assange is a journalist or not. But is there some underlying respect for the role of journalism, specifically freedom of speech, Article 10, which gives journalists perhaps greater protection than you might have by some carefully worded statute? Who wants to comment on that? Jodie?
Well, I think I take heart from the judgment in the Northern Ireland case last month that, though we haven't had the written judgment yet, it was quite clear that the court viewed the actions of the police as have been completely unwarranted, if I can use that phrase. And so that does give me heart. Fortunately, we see, I would say, we don't see that many cases, fortunately, coming to be able, I think, to say definitively whether the entire judiciary is positively inclined towards the press. But I would say between the strong Article 10 protections given by the European Court and the European Convention and some of the recent judgments that we've had, of the few cases that we've had, I think I would be somewhat positive.
David?
Well, I was thinking anecdotally, I did a case called Gaunt, which went through the High Court of Appeal, then up to Strasbourg, and I was doing it for Ofcom, and it was a case about a shock jock, John Gaunt, who said some pretty incautious things while interviewing a council official, described him as a little Hitler and so on. And a little careful what I say, but Ofcom obviously considered this a very marginal and difficult case, and in the end they rapped the radio station on the knuckles. They reprimanded them without imposing any sort of sanction on them. But nonetheless, the Article 10 case was brought, and it was apparent to me that the judges, certainly in the UK, found it a lot easier than Ofcom had. They thought it was outrageous calling people a little Hitler on the radio, particularly close to Remembrance Sunday, which was one of the points that was made. And I wondered almost if it was an age thing, if it was a generational thing, more than anything else. But of course they rally and they loyally apply the Strasbourg case law, and we've seen examples of that. We've talked about examples of that. I'd love to know what happened, by the way, in the if it was tested in court, these attempts to get your material out of you from Syria.
Yeah, I'm not allowed to talk about that.
No, I suppose you're not, but I would still love to know.
You get free legal advice.
But what I'd love to hear from Alex... what I'd love to hear from Alex, he mentioned this public interest defence, and I don't know what exactly that would look like, but if it looks anything like the exercise that prosecutors are supposed to perform under that CPS code that I mentioned, that's deciding whether the public interest served by the conduct in question outweighs the overall criminality. Well, what a horrendous decision for a judge to have to make. Where are the guidelines? Maybe 5-6 years on after Snowden, we're beginning to come to some sort of assessment as to whether, on balance, the transparency that he ushered in was worth the undoubted damage that he did to national security. But how is some poor judge supposed to make that decision at the time? I have real difficulties with that.
Alex?
Well, I'd start at that end. I think you can have a public interest defence. We have one in the Public Interest Disclosure Act, for example, for whistleblowers in employment context. And it's not easy to apply, obviously, but you can sit down, you look at the extent of the wrongdoing that you're exposing, and you look at whether the revelation that you are making is proportionate to that wrongdoing. It's not easy, but I'd rather that a jury made it or that a judge made it than a prosecutor made it behind closed doors, because the public interest, without being too corny, requires some input from the public. In order, particularly when you're talking about disclosure of wrongdoing by the authorities, and lots of the examples I've given have shown the authorities doing stuff in our name but keeping it secret. But I think one of the, overall, my view is that the courts are pro-media. Obviously, they've been given a healthy dose of steroids by Article 10, and things have got better. But we need to be careful, because the sort of cases that we're talking about, just because they end up with press victory, I don't think you can simply say that's the courts working well. Because you take David Miranda's case, say, the powers, I agree, are breathtakingly broad. The courts actually decided that in David Miranda's case, although he was there in a judicial review represented by Bindmans, paid by The Guardian, they said it was unrealistic to suppose that the average journalist passing through a border would have Bindmans on the speed dial and the wherewithal and the resources to get to court and have the court declare that actually these powers needed extra safeguards. So although that was a victory for press freedom, I think that's actually an example of an overbroad law and where we got the calibration wrong rather than the system working as it should.
And Rohit, I presume that before you can put anything on the air, you have to satisfy the ITV lawyers.
Yeah, absolutely. And we have two stages of, we're an independent programme maker at ITN. We have our lawyers and then we have the broadcasters' lawyers. So there are two stages of this. It's a difficult thing, and we should all have Bindmans on speed dial.
I think we plugged Bindmans quite enough already. This is like the shopping channel.
No, absolutely, No, absolutely. But I mean, one point to add is that yes, although there is something to take heart from in the Northern Ireland case, everything that went before that, to me, reveals the instincts, this sort of growing reflex action that many journalists fear from police investigators when it comes to cases like that. And, a lot of the evidence is anecdotal, but it does feel that there is more of that.
Alex, is Julian Assange a journalist? And what's going to happen to him? How are the courts here? Going to deal with it? And what's the role of the Home Secretary? All in 30 seconds.
The issue of whether Julian Assange is a journalist is very difficult, and I have to declare an interest. I advised The Guardian in relation to the publication of the WikiLeaks material. So I declare that, and that's in the public domain. But the issue of whether Julian Assange is a journalist is very difficult, because if he is, then what about all the other outlets that receive that material and so on? And I don't think you can answer that in a straightforward way. And so I'm going to dodge that. I think in reality, you look at the extent of what was published and the likely audience and the capacity in which he did it, and those sorts of factors. And that is a mixed question of fact and law, as we said. It doesn't matter whether you're under the Espionage Act or under our definition. As to what happens to him in the role of the Home Secretary, I mean, without going too much into extradition, obviously the reality of the position now is that there is a new US indictment, a competing request with the Swedish sexual allegations, and at some stage the Home Secretary has to decide which takes precedence before the English courts, and in making that decision the Home Secretary has to take account of things like the relative gravity of the charges and when the allegations were made. And obviously therefore it's highly significant that the charges against Assange have changed, superseding indictment. He's not merely alleged with a hacking offence, as will become clear. He's alleged to be involved in the Espionage Act publishing offences.
And if you were advising the Home Secretary on the relative seriousness of rape and espionage?
I'd be conflicted.
Good answer. Nobody else, I suspect, wants to join in on that one. So where do we go from here? I mean, we have a great deal of concern. We have a great deal of legislation. But David, you're suggesting that there is a bit of a balance that can be struck, and that there is respect in Parliament, among governments, and so on, and I think among the courts for people who are doing a serious job, and even among the people that you used to deal with. Obviously, the Snowden revelations were very upsetting to them, but they were a bit of a wake-up call to the security and intelligence services.
Yes, I mean, I would say that certainly in relation to the activities of the British security and intelligence agencies, this may be a controversial view. Nothing in the Snowden material demonstrated that they were necessarily acting unlawfully. What it did demonstrate was that our laws are so astonishingly broad and opaque that almost anything they might have chosen to do would be lawful. I'm slightly exaggerating there. But yes, it was a wake-up call. How one would have defended, how one would have operated the public interest defence in that case, I don't know. I suppose everyone would have been looking for the nugget, the one possible unlawfulness that might have justified the disclosures. On the other side, you'd have people saying, well, these freedom of information laws have limits for a reason. The Official Secrets Acts are there for a reason. Protective markings on these documents are there for a reason. So I don't know what the answer to that would be. Yes, and I did put a lot of emphasis on the courts and on Parliament. They are vital arbiters, but I also entirely agree that they're not the whole story. And to my mind, and I haven't yet read the judgment in the Northern Irish case, I'm not sure whether it yet exists, but the lesson I would seek to draw from that case is my goodness, the police need good lawyers. And were there really lawyers in the Durham Constabulary or in the PSNI saying that sort of behaviour was appropriate? That's really worrying if so. And you can have all the regulators you like, and I apply the same thing to the security and intelligence agencies, but without a genuine culture of compliance and a rule of law culture in those organisations, the regulators are going to be imperfect instruments, and they're not going to get to the bottom of everything. I used to shudder. Jonathan will have this pleasure in future. Every time people said nice things, even the Supreme Court said very nicely once, these Schedule 7 powers that were mentioned, the port powers, well, they're okay. They're very strong, but they're okay. And one reason they're okay is it's a wonderful independent reviewer, and he keeps an eye on everything. I can't possibly be in every port and every airport in the country when police officers are stopping people for whatever reason. And one has to be very careful not to be used as a fig leaf or sort of a carapace to protect them from justified criticism. So yes, it's about education, it's about a compliant public sector. My sense is that despite the revelations, which I think haven't been mentioned, or perhaps they were at the beginning, that came out of MI5 yesterday in the Liberty litigation, on the whole, by and large, we do have that. But that example of the Durham Constabulary is a very worrying one, and I hope the police lawyers learn from it.
Yes, you're exposing things, but no, you're not working for the authorities.
Precisely, and that's where the line is. And you know, the sense among a lot of journalists on this beat is that increasingly, perhaps over the, you know, really over the over the lifetime of you know, the Islamic State caliphate, I think there's a sense that we've increasingly been sort of co-opted in to their work, like unwillingly, because of this increasing use of production orders, etc. And you know, yes, you know, technology helps us in a way. I mean, it helps everyone, but the increasingly aware that there are bits that journalists are looking at that the authorities aren't always looking at. And you know, I think most news organisations would be happy to share the information they have, as long as it protects their sources. If there is a genuine threat to national security, I think where people would push back within news organisations is really when they feel either that it's a fishing expedition, or if it's doing the work that could quite easily be done by police investigators.
I mean, Jodie, does that put journalists in danger if the bad guys think that the journalists are working hand in glove with the authorities?
Absolutely. I think this is why it's vital that you're right. One of the key roles that journalism plays within a democracy is to expose wrongdoing. And I think journalists are at threat in a number of ways. Obviously, one is if journalists are seen to be in cahoots, if you like, with the government, and therefore they become targets themselves of the likes of ISIS or indeed organised crime, for example. So that would be one. If you think, if you're whistleblowing on organised crime and you think that your journalist that you're speaking to is not protecting you might choose to take out that journalist. So it's absolutely vital that there's that separation. But I think the other thing is, and this is absolutely key, is that there's a reason that journalists need to be independent, because that also gives them the freedom to expose the state as well. And therefore it is really important that while you may choose to give the state information about a crime, you also want to be able to ensure that you are really able to protect information that relates to the committing of crimes and abuses by governments. And that's why I'm increasingly worried about things like these overreaching warrants that I think in part comes out of something we haven't really talked about, which is a total lack of understanding about how technology works and how to deal with matters digital. You want to find an email that will tell you who the leaker of some secret is, for example. So you go in and you say, I'll take your entire database, thank you very much, which may well contain information that you as a journalist want to keep secret for all sorts of reasons, including because you might have information that will expose the state itself. And I think as we look to, you talked about how getting the balance right, I think one of the things that we have to be really alive to is the development of legislation that relates to the online world in a way that may well negatively impact journalists and journalistic activity. And I'm not sure that we are sufficiently alive to that. We've thought about it a lot in terms of surveillance, perhaps belatedly, but less so in terms of things that are actually published or where indeed journalists are storing their information.
For 13 years I've been informed, and it feels like yesterday, UCL and Bindmans have been co-hosting, co-running these debates together. And I can speak without fear of contradiction that all 13 of them have been absolutely wonderful. Informed by Bindmans' focus on what's happening on the ground, with what's actually happening at the cutting edge of legal issues. We've been able, working together, to put together a fabulous sequence of debates, and this evening has been absolutely no exception. It's been a tremendously good debate, tremendously interesting to all of us. I'm delighted that Bindmans got such fabulous free publicity. And I would certainly echo, reading the cases coming through, I would certainly echo the takeaway lesson from this evening, the key takeaway lesson, whatever, about media freedom, which is you should all have Bindmans on your speaker, or fast call, or whatever. That, I think, is the key lesson, if nothing else, to take away from today's debate. And But I'll wrap things up after that further bit of free advertising. There are drinks outside the door for all of you to partake in. And I'd like to conclude by inviting you to give our fabulous panel and our fabulous chair, Joshua Rosenberg, a well-deserved vote.